Good morning and welcome to another edition of the Senate Committee on Commerce and Labor. Today is February the 22nd. I'd like to welcome everyone here. Madam Secretary, please call the roll.
Senator Buck? Here. Senator Daly? Here. Senator Hammond? Here. Senator Lang? Here. Senator Pazina? Present. Senator Scheibel? Here. Senator Stone? Here. Chair Spearman?
Here. Thank you, ma'am. Let the record show that everyone is present. I want to welcome our audience that's here in Carson City, in Las Vegas, and those who are listening over the internet. Listening on the internet remotely today, we have a very full agenda with 3 bills for a hearing and 1 for work session. I'd like to take a moment to go over some housekeeping items. As you know, these meetings can be viewed through our streaming service on the legislature's YouTube channel, both of which can be accessed on the legislature's website. There are various ways members of the public can engage with us and participate throughout the process. These include in person in Carson City or in the Grant Sawyer Building in Las Vegas. Telephonically, instructions for telephone participation is available on today's meeting agenda. And if you are listening and you are going to testify telephonically, I'd encourage you to please make sure that you're listening to BPS when they call the last 3 digits of your number. Or you can submit written comment to the committee email address listed on the agenda. But you must submit this. Any testimony for today must be submitted today. We can't keep taking testimony till like 6 months out. So if you're going to testify on a hearing, you have to do that on the day of the hearing. Or you can share your opinion via the legislature's website application on Nellis. Anyone wishing to testify in person should sign in at the table by the door, and please present a business card if you have one to the committee secretary. Any exhibits for the committee must be submitted in electronic format no later than 8:00 a.m. the day before the meeting. Submit exhibits to our committee manager, Terry Miller, or our committee analyst, Cesar Magarejo. Committee contact information may be found on the Nellis page in Nellis. When testifying, please make sure that you turn your microphone on and speak clearly your name and your entity that you represent at the beginning of your testimony. Please speak clearly and project your voice. If you do not project your voice, there are several people who may be listening over the internet and they will not be able to hear you. Please remember to turn your microphone off when you finish speaking. And just a reminder, and I need to make sure everyone hears this and understands it, pursuant to Nevada Revised Statute 218E.085, it is unlawful for any person to knowingly misrepresent facts when testifying before a legislative committee. A person who knowingly does so is guilty of a misdemeanor. In addition, both the chair and members may request any testifier to submit documentation supporting their testimony. All committee-related information is available on Nellis, which is accessible from the legislature's website. And finally, please, please, please turn off your electronic devices, especially your cell phones, or put them on silent mode during the meeting. And so we will begin with a work session, Senate Bill 91. Mr. Magarejo.
Thank you, Madam Chair. For the record, Cesar Magarejo, Committee Policy Analyst. Our only bill in the work session today is Senate Bill 91, which authorizes a licensed clinical alcohol and drug counselor to supervise a certified problem gambling counselor intern. This bill is sponsored by Senator Lang and was heard on February 15, 2023. The bill authorizes a licensed clinical alcohol and drug counselor who has completed specific training in problem gambling and the supervision of interns and is approved by the Board of Examiners of Alcohol, Drug, and Gambling Counselors to supervise a certified problem gambling counseling intern. And Madam Chair, there were no amendments at the time this work session document was drafted.
Thank you, sir. Committee members, are there any questions? The bill. Okay. Well, I will accept a motion to do pass. So I have a motion by Senator Scheibel and second by Senator Stone. Is that Stone? Stone? Daly. Senator Daly. So are there any additional comments? Okay, Madam Secretary. I'm sorry, any opposed? It's unanimous. So We'll record this as unanimous. Yes, do pass. And Senator Lang, would you be responsible for the statement on the floor? Yes. Okay, thank you. Thank you. So I'll now open the hearing on Senate Bill 57. The measure revises provisions relating to insurance. And I will ask committee members when we get to questions if you will do one question initially, because we have 3 bills that we have to hear, and then after the public has testified, I'll come back around to committee members. So we'll do first bite and then come back around, okay? Good morning. Please begin when you're ready.
Thank you. Good morning, Chair Spearman, Vice Chair Lang, and members of the committee. My name is Nick Stosic, and I am currently serving as the interim insurance commissioner for the state of Nevada. It's my honor to be here today representing the Nevada Division of Insurance to present Senate Bill 57, which is the division's omnibus bill. I'm also joined today by our Chief Deputy Commissioner, Stephanie McGee, and Chief Legal Counsel, Alexia Emmerman. Due to the unique natures of risks and hazards in different parts of the country, Congress has left the regulation and ability to tax insurance up to the states. The insurance industry in Nevada has grown from $11 billion of written premiums in 2012 to over $22 billion in 2021. The insurance premium tax is the state's 4th largest contributor to the state's general fund, with $1.2 billion of revenue being projected by the Economic Forum for this upcoming biennium. The Division of Insurance is first and foremost a consumer protection agency, with our mission being twofold: to protect consumers in their insurance experiences and to maintain a stable and competitive market. The insurance is a heavily regulated industry because of the potential financial risks and impact both the consumers and businesses. It requires that division staff have specialized knowledge of risk, finance, insurance contracts, fraud, and customer service. For the purposes of regulating insurance alone, the division is responsible for regulating 59 individual chapters within the Nevada Revised Statutes Title 57, and we share 4 additional chapters regulating workers' comp insurance with the Division of Industrial Relations. The Nevada Division of Insurance regulates approximately 1,700 insurers that are authorized to write business in our state, along with just under 150 captive insurers that are domiciled in Nevada. The number of licensed producers in Nevada has grown by roughly 100,000 over a 2-year period, growing from approximately 150,000 licensed producers in 2020 to roughly 250,000 today. For fiscal years 2021 and 22, the division's consumer services section responded to approximately 25,000 consumer inquiries and investigated roughly 5,000 consumer complaints regarding the activities of insurance companies, insurance agents, bail agents, title agents, service contract providers, and other regulated entities. Through its efforts, the section recovered close to $8,900,000 for Nevada consumers during this period. And I'll now provide you with a brief review of the changes proposed in our bill. Since the bill addresses numerous chapters in Title 57, we have provided you with a listing of the individual chapters within Title 57, along with an explanation table for SB 57, which provides both the summary of the changes being made and a corresponding rationale for each change. Section 1 of the bill changes the current requirements for health carriers submitting a copy of every provider denial letter to the commissioner to now submitting a report which summarizes the provider denial, network denials, along with making a copy of every denial letter available to the commissioner upon request. This change will allow for a more efficient collection of provider denial data and will foster efficiencies to both carriers and the division. As we address Section 2, I want to mention to committee members that the division met yesterday with Matt Sharp and Victoria Kulbaugh of the Nevada Justice Association to discuss Sections 2 and 21, and they later provided us with language for potential amendments to both sections. We greatly appreciate the opportunity to hear their thoughts and to continue to work with them on these sections. I've asked our Chief Legal Counsel, Alexia Emmerman, to briefly address Section 2 with you this morning.
Good morning, Alexia Emmerman, Chief Counsel, Division of Insurance. Under Section 2, the division seeks to make confidential certain information that relates to matters investigated by the commissioner, but that that end up in a warning or in non-agency action or other informal disposition. Non-action. It also authorizes the commissioner to classify as confidential certain records and information relating to deliberations and makes these deliberative records not subject to subpoena unless the commissioner, except that the commissioner can release it if it doesn't affect an investigation or a court orders the release. From our perspective, open and honest communication is imperative to effectuate the purpose of the insurance code. It sometimes takes considerable evaluation, collaboration, and hypotheticals to understand how agency decisions would impact the insurance market, the industry, the licensees, consumers, and the public. Often there's no one person at the division who can provide the analysis needed. It has to be a team approach with a lot of what-ifs. Division investigations include these internal discussions to fully understand the laws, the evidence involved, as well as the potential results or consequences of the proposed action. To properly regulate, the division needs a devil's advocate to avoid these unintended consequences. And staff is concerned about unfiltered thoughts becoming public. It does not freely share these honest thoughts. And the ability to have these honest thoughts and unique ideas makes the division more able to protect consumers, competition, and Nevadans. Some of these discussions are captured in our records, but some are not. And the division's concern with our deliberative records is that releasing this information and hypotheticals could actually harm the people in the industry because we've seen the inferences made from this information and they really don't serve transparency, justice, or fairness. Thank you.
For the record, Nick Stosic with the Nevada Division of Insurance. So I'll move on to Section 3, which removes the phrase threatened act and adds language that is related to the business of insurance in subsection 2. This section also moves the deadline for holding a hearing from 30 to 60 days, and it also provides that the commissioner shall issue a final order in a contested case within 45 days after the close of the hearing. The changes are necessary to simplify important deadlines, which will ensure the division can efficiently manage cases and limit the misuse of the provision to request hearings, because current language is vague and often allows for hearings for essentially any reason. Section 4 makes confidential, with exceptions, additional records and information related to the investigation for the prosecution of insurance fraud, and requires such records and information to remain confidential after the conclusion of the investigation. The new requirements are necessary because criminal investigations are sensitive, and disclosing investigation information could undermine case prosecution. Section 5 revises the terminology used to describe fees in NRS 680B010 to match the language that is used in the statutes. The amount of such fees remain unchanged, and this section is also removing duplicative fees. The change will allow users of the insurance code to better understand and interpret the requirements for these license types. Section 7 requires a managing general agent to file and maintain with the commissioner a surety bond in the sum of $50,000, And this is intended to match the licensing requirement of other similar NRS 683A applicants. Section 8 requires an administrator to notify the commissioner within 30 days of changes to the administrator's members, owners, directors, or officers, along with changes to their physical location, mailing address, or electronic mail address, or a legal or fictitious name. Section 9 revises NRS 683A-025 to provide clarity that any person who administers a program of pharmacy benefits for an employer, insurer, internal service fund, or trust must be licensed as a third-party administrator. Many pharmacy benefits are already obtaining Nevada administrators' licenses. However, we have been receiving pushback from some PBMs, so this clarity is helpful to properly enforce the statutes. Section 11 and 12 revise requirements for an out-of-state applicant for an administrator certificate of registration to include in their application the authorization document issued by their home state and requiring the applicant to comply with all applicable provisions of Title 57 and related regulations to renew their authorization. These revisions enable the divisions to verify out-of-state licenses and ensure compliance with Nevada law. Section 13 clarifies that subcontracting is not permitted between two third-party administrators and that liability may not be transferred under such agreements, even between contracting parties. The prohibitions are necessary to ensure contractual duties are performed and to ensure adequate recovery for wronged parties. Section 14 adds language to allow the commissioner to require an applicant for a license as a managing general agent to submit a copy of any contract between the applicant and each insurer that the applicant will represent as a managing general agent, in addition to meeting the bond requirements contained in Section 7. Sections 15, 19, and 36 authorize the commissioner to renew a temporary license as a producer of insurance, independent adjuster, and exchange enrollment facilitator for one additional period of 180 days under certain circumstances, such as concluding estate matters or completing tours of duty in the military. Sections 16 through 18, 20, and 40 through 42 revise provisions concerning the licensure of insurance consultants, business entities, adjusters, insurance agents, and firms or corporations to both clarify and standardize the circumstances in which an agent of an insurer is required to designate a natural person to represent the agency or to be responsible for the agency's compliance with the laws and regulations governing insurance. The term appointment is also removed from the statutes in favor of the term sponsorship because the division views these terms as distinct, which will also allow users of the insurance code to better understand and interpret the requirement for each license type. Section 21 clarifies that NRS 687B 420 applies to policy cancellations of certain life and health insurance policies issued under NRS chapters 688B, 689A through C, and 695A through F. Policies issued under these chapters require cancellation cannot be effective until at least 60 days after the policyholder is provided with notice of cancellation, rather than the 30 days notice that's allowed for property and casualty policies. Section 22 prohibits an individual and small group health benefit plan insurers who have removed a prescription drug from a formulary from adding that same prescription drug back into the formulary at a higher cost tier in the same plan year, it was removed, except at the times and under the circumstances provided under existing law. Current statutory language has provided a loophole that enables a carrier to remove a drug from their formulary and then add that same drug back at a higher cost during the same plan year, thereby circumventing the statutory intent of NRS 687B 4095. Section 23 reduces the minimum allowed rate for determining annuity non-forfeiture benefits from 1% to 0.15% to both help ensure insurer insolvency and to bring Nevada annuity non-forfeiture rules in line with the National Association of Insurance Commissioner model law updates. Section 24 allows for the sale of contingent deferred annuities in Nevada by clarifying that this type of annuity, which is designed to provide guaranteed lifetime income payments if an investment account is exhausted during the lifetime of an annuitant, are not subject to non-forfeiture rules because contingent deferred annuities are not designed to accumulate value. Sections 25 and 27 relate to prepaid contracts for funeral and cemetery services and clarify the requirements of NRS 683A-301 apply to an applicant for a certificate of authority. The intent behind this change is to ensure that the names of funeral and cemetery sellers are not deceptively like existing entities, which provides a layer of protection to consumers and businesses that are currently licensed in Nevada. Section 26 requires a person to have a good business and personal reputation to qualify for an agent's license to sell prepaid contracts for burial services on behalf of a seller. Most licensees under Title 57, including a funeral agent, are required to have a good business and personal reputation to be licensed, so this language necessarily standardizes the requirements for sellers of burial contracts with other Title 57 licensees. Section 28 replaces the definition of term health benefit plan in NRS 687C-075 with the definitions used in NRS 687B-470 to help promote statutory consistency and reduce potential confusion of having multiple definitions of the same term. Section 29 clarifies that the provisions regarding confidentiality and disclosure of certain records and information that currently apply to traditional insurers would also apply to captive insurers domiciled in Nevada. Sections 30 through 32 moves the annual filing deadline of the Statement of Financial Condition for various types of captive insurers from March 1st to June 30th. This change will allow captive insurers to provide annual report filings using audited financial information. In addition, because traditional insurers' filings are due on March 1st, this change will allow for better use of division's analysts' availability regarding financial report reviews. Sections 33 through 35 make conforming changes necessitated by the renumbering of the fees table included in Section 5. Section 37 provides that Nevada rules of civil procedure do not apply at delinquency proceedings against an insurer, which is necessary because receivership petitions are extremely time-sensitive. Discovery is neither appropriate nor necessary to protect policyholders and other creditors in an insolvency, and discovery could also result in a waste of estate assets. Section 38 eliminates duplicative statutory language regarding the powers of the commissioner as a receiver, rehabilitator, or liquidator of an insurer. The intent is to remove potential confusion regarding language of authority and compensation of those hired in receiverships and to ensure the NRS are consistent with the Uniform Insurers Liquidation Act and the Insurer Receivership Model Act. Section 39 adds language to clarify when a receiver is to be appointed in delinquency proceedings for an insurer, certain persons that may be appointed and certain staff that may be employed in relation to the delinquency proceedings serve at the pleasure of the commissioner. The added language ensures that the NRS are consistent with Uniform Insurer Liquidation Act and the Insurer Receivership Model Act. Sections 43 and 46, establish that only a bail enforcement agent is authorized to take certain actions with respect to the apprehension and surrender of a defendant. Section 43 also removes the term dwelling in favor of the term structure. These changes are necessary because bail enforcement agents and bail agents continue to use unlicensed persons to locate and apprehend defendants. Bail enforcement agents must meet very specific qualifications to engage in locating, apprehending, and surrendering defendants who have failed to appear in court. These qualifications, which include rigorous training, distinguish the bail enforcement agent from the bail agent. Some statutes state that bail agents can locate, apprehend, and surrender defendants, which clearly contradicts the definitions, qualifications, and training of the two licenses. Changes are also needed to ensure bail enforcement agent safety, because Nevada allows persons to defend their homes with deadly force and require a level of reasonableness for a bail enforcement agent's locating and apprehending tactics. This is a very important issue in Nevada, as we've experienced several bail apprehension-related shootings as recently as 2021. Finally, the definition will change dwelling to structure, and that is necessary because a defendant might be in a structure that is not necessarily a dwelling. Section 44 provides that a bail agent who improperly causes the surrender of a defendant to custody is not entitled to collect fees related to the surrender. Section 45 prohibits a bail agent, general agent, bail enforcement agent, or bail solicitor from allowing any person other than a licensed bail enforcement agent to participate in the functions of a bail enforcement agent. And finally, Section 47 removes the phrase threatened act from existing language in NRS 315.725 sub 9. And this revision signifies a necessary change conforming with Section 3, which relates to simplifying hearings regarding whether an insurer or an employee of an insurer has engaged in unsuitable conduct and for any other purpose within the scope of the insurance code. So I appreciate you bearing with me through this long bill. This concludes my introduction of SB 57, and we look forward to answering any questions of committee members.
Thank you, Mr. Stosik. So anyone else going to present with you, or?
That will be all for the presenting, and both Stephanie and Alexia are here to help answer any questions.
Okay. Committee members, any questions? And we have 3 bills, so please, let's do one question now, and then after public comment, we'll come back. Any questions? Senator Daly.
Thank you, Madam Chair. And in the interest of time and not taking up too much of it, I have asked the Department of Insurance to come and see me for the 8 or 9 questions that I do have, but I'm not going to ask them. You can answer them later, but the sections, just for the record, Section 2 regarding the revised language on confidentiality, Section 2 in sub 9 also on confidentiality and the deliberations, Section 4 sub 3, page 9, also confidentiality. Question in Section 7 on the bond. Question is Section 11, sub 13. No, excuse me, never mind on that one. Section 13, sub 5, about the limits and the various things that you're looking for administrators and delegation. The drop in the 1% to 0.15, I have questions on that in Section 23. And then Section 37, the civil procedures, if you're eliminating that, what are the rules going to be? And then Section 43, the dwelling to structure needs a definition. That was it. Thank you, Madam Chair, and they'll come and talk to me later.
Anyone else? Senator Stone.
Thank you, Madam Chair. I have a number of questions, but I'll keep it to one for now. With regard to Section 26 for prepaid funeral expenses, you say that the entity must be a good business and personal reputation to qualify. to sell prepaid contracts for burial services on behalf of the seller. My question is that while that's good and well, what happens if you prepay for funeral expenses at a ABC funeral home, and what if the funeral home goes out of business? Is there a bond that's required that will protect the consumer so that they will in fact have those services delivered?
Alexia Emmerman for the record, through Senator Spearman to Senator
No,
Stone.
just go direct. Go
Thank you very
direct.
much. Anybody who is getting a specialty license, of which a funeral and cemetery licensee is, they are required to get a bond for purposes of protecting people. They're also required to deposit the funds they receive into a trust so that they become available, that they're always there, and then they submit information to us for the solvency component.
And I assume, if I could just follow up, that the funeral home would need to communicate that trust and report to the insurance commissioner about its validity, and the funds are still there each year.
Senator Stone, Alexia Emmerman for the record, yes, they do need to keep in communication with us, and they are subject to solvency oversight.
Thank you so much.
Committee members, additional questions? Okay, thank you so much. We will go now to those in support of Senate Bill 57. Here in Carson City, I don't see anyone in Las Vegas, but in case you're hiding behind one of the chairs, come to the table.
Thank you, Madam Chair. Good morning. Michael Hillerby on behalf of the American Council of Life Insurers. Here today to thank the division for their support and putting these bills forward. Having a uniform set of regulations as worked on by the National Association of Insurance Commissioners across states help provide consumers with predictability and the industry. So those tools that they use through the NAIC and the division, some of those are included in this bill today. We appreciate their hard work and support of those and are happy to support the bill. Thank you very much.
Thank you. Anyone else? Support? BPS, anyone on the phone?
If you would like to testify in support of SB 57, please press star 9 now to take your place in the queue. Again, if you'd like to testify in support of SB 57, please press star 9 now. Chair, you have no one wishing to testify in support at this time.
Thank you. So we'll go now to those in opposition. Anyone here in Carson City or in Las Vegas?
Good morning, Madam Chair. Matthew Sharp for the Nevada Justice Association. I should say we are in support for certain sections and have limited opposition to others. Section 21(3) in particular, we are in support of to conform, won't get into the legal details, but essentially to conform that cancellation of insurance policies in health insurance conform to two competing statutes. And we're working with the division on specific language to accomplish that. With regard to Section 2(3), without addressing the details, unless the committee would like to hear them, we just think, I guess in a nutshell, that the breadth of the confidentiality is too broad and restricts courts from ordering relevant documentation in civil or criminal litigation. And, with that, we are, as Mr. Stosik said, working with them on language, and we appreciate being able to work with the commissioner in that regard. So with that, if you'd like to, any specific questions, I'm happy to answer them.
So I just have one. You said sections 2 and 3. Can you give me an example of something that you consider too broad?
Section 2, Part 3, I mean, there's several within that section, but basically the idea has always been that when somebody is under investigation, that the materials relating to that investigation are confidential, So the example I was thinking of as I was driving out is if you have a car accident, for example, and the police officer investigates that accident, while the accident is being investigated, there's a level of confidentiality, which we can all figure out in the context of should we accuse somebody of a crime, et cetera. But once the police make a decision, the content of that investigation is a public record. And that's basically the same idea that exists currently under Title 57. And the fact is, in certain instances, at least in my experience, deliberations and contents of communications between insurance companies and the insurance commissioner can be relevant in a civil lawsuit. For example, insurance companies may take different positions with the insurance commissioner versus what they say in a courtroom. So those are examples. I mean, the idea, I think, from a policy perspective is that the public should have a level of transparency to know who they're dealing with in terms of critical issues like purchasing insurance, which agent you use to go buy life insurance, those sorts of things. Did that address your question, Senator Spearman? I mean, I can get into the specifics if you'd like or after this hearing.
Yeah, why don't you come see me afterwards? But I think you addressed it. I have a question for Mr. Stosik on court orders, but that's good for right now, but come see me, okay?
Okay, thank you.
Anyone else have questions? Okay, thank you, sir. We will move now to those neutral. I'm sorry, opposite. Yes, opposition. Oh. I'm here today, not tomorrow. I'm here. Anyone in opposition on the phone?
If you would like to testify in opposition of SB 57, please press star 9 now to take your place in the queue. Again, if you would like to testify in opposition, please press star 9 now. Caller with the last 3 digits of 178, please continue.
Hello, my name is John Carlo for the record. And Mrs. Spearman, am I allowed to comment on automotive insurance?
If you're in opposition, you can say why.
Right. Well, I'm sort of in opposition and I'm sort of in favor of part of the bill. What the previous guy was talking about, I do think that the way that insurance is investigated needs to be looked at, but more importantly, I've tried to contact the insurance commissioner about Teslas and how their failure and their how they're wrecking and they're causing property damage and how they're raising our insurance rates. We have some of the highest insurance rates. And also what needs to be discussed is the THC in being allowed in the workplace because alcohol and cigarettes, those numbers statistically are 10 times the percent of what the numbers are for marijuana and causes damages, deaths. Alcohol caused so many deaths where you compare it to THC, it's almost nothing. So we need to be discussing that, but we need to be talking about our high insurance rates and also bringing down the price of Teslas. And I hope that when you guys decide to build the semi-Teslas, that you don't make them self-driving, because that's an accident that's just waiting to happen. And our insurance department in this state needs to pick up their phone, because I could never get on the phone with them. And I was given a very bad attitude from everyone from the when I was trying to call and find statistics on Teslas that are being wrecked in Nevada. I could not get that information. So I would like the insurance commissioner's office to make that available. Thank you, guys.
Thank you, sir. BPS, anyone else in opposition?
Chair, you have no more callers in opposition at this time.
Okay, we'll come back to Carson City. or opposition?
Yes, thank you, Madam Chair. My name is Helen Foley, and I represent the Nevada Association of Health Plans, and that includes 10 organizations in Nevada that provide commercial health insurance. While we concur with almost everything in the bill, there are a couple of sections, Section 8 and 9, that we would like greater clarification and maybe further understanding. It was with the pharmacy benefit managers, as well as in Section 8, we feel that it's overly broad for everyone within the organization, a member, owner, director, officer, to be able to notify the commissioner within 30 days. We feel that it's more appropriate that those that are handling business within the state of Nevada rather than the major corporations. So there's just a few things, and we appreciate your indulgence.
Thank you, ma'am. Anyone else in opposition? Is there anyone wishing to testify neutral on this bill? Carson City or Las Vegas? BPS, anyone on the phone?
If you would like to testify neutral on SB 57, please press star 9 now on your phone. Chair, you have no callers wishing to testify neutral at this time.
Thank you, ma'am. And so I'll bring Division of Insurance back. And committee members, if you have any questions, now is the time to do that. Any questions, committee members? Okay. Mr. Stosik, comments?
I'd like to thank the committee for hearing this bill today. We know our omnibus bill always contains a lot of sections and chapters, and so we appreciate that opportunity. We also look forward to meeting with Senator Daley and the other members that testified to work on the sections they have any issues with. And again, for the record, this is Nick Stosik from the Department of Insurance, or
Thank you,
Division
sir.
of Insurance, excuse me.
Senator Stone, I neglected to call on him.
No, you didn't. Thank you, Madam Chair, and thank you again for the presentation. Just a couple of brief questions. The first one related to the PBMs. I appreciate the language in here that you want to protect the consumer from them taking a drug off the formulary and then later putting it back on the formulary at a higher tier. So as you know, there's a lot of new drugs that are coming on the market, and what the PBMs do is they will pit one drug against another if they work by the same pharmacological benefit the same way. It's the same mode of action. So would it be possible to amend this to also say that a PBM cannot take a drug of a certain pharmacological class off the formulary and put a drug with the exact same pharmacological class on the formulary at a higher tier? That would protect the consumer as well, because they have to stay within that type of drug. And if their only choice is to go to a higher tier, it's certainly not to the benefit of the consumer. And I'd be happy to discuss this with you a little bit. It's kind of technical, but I'd be happy to discuss with you offline about the merits of doing something like this.
For the record, Nick Stosik with the Nevada Division of Insurance. And Senator Stone, we'd be very pleased to meet with you to get your ideas on how to modify that section of statute. So thank you.
I appreciate it. And then my second question refers to the bail industry. So, and I think that the protections that you're talking about are very important, especially when somebody can use force to defend their domicile, whether it's a car or whether it's a structure. But when a bail agent is considering giving bail to somebody, especially if it's a high-value bail, the defendant or their relatives that are putting up the collateral, if you will, for the bail will often have it written into the contract that if the defendant doesn't show up to court, that they agree that the bail agent has a right to enter their home, whether by knocking on the door or breaking the door down. That's kind of a unique practice that bail bondsmen have, or bail apprehension agents have, in contrast to law enforcement. I also like the fact that you have to call law enforcement to accompany you for an apprehension. But how would this contract supersede what you're trying to do here in this omnibus bill, or would the omnibus bill basically say that that contract is not valid?
For the record, this is Nick Stosik with the Nevada Division of Insurance. And Senator, really the intent here would not change that type of contract. It's just currently bail agents do not have really the training or the authority to apprehend. That's really the issue here, is those that are bail enforcement agents go through specific training to train them for the type of situations they're going to experience. And as a bail agent, really it's similar to an insurance agent. You are trained and have to go through the process of learning how to sell bail bonds. So they're very distinct functions. The challenge that we've had is, even though the law says you must use a bail enforcement agent to apprehend, we've had numerous cases where either somebody that's unlicensed altogether or bail agents that don't have the training to properly apprehend. And also, again, the risk that they're encountering if they encounter force. All we're trying to do is really make sure the protections are there. But again, your question about would that override the contract, it should not.
And are the bail enforcement agents, are they licensed separately from bail bondsmen?
For the record, Nick Stosik with the Nevada Division of Insurance, they are totally separate licenses, and to my understanding, they must be separate. So you can't be both a bail agent and a bail enforcement agent. Is that okay? I will leave that to our resident expert.
Thank you.
Alexia.
Senator Stone, Alexia Emmerman, for the record, from the Division of Insurance. So a few things to answer your questions. A bail enforcement agent and a bail agent are two totally separate requirements for those licenses. They can exist concurrently. So a bail agent can also have a bail enforcement agent license as long as they meet all the qualifications and go through all of the training. Because a bail agent has to be 18, has to be a resident, has to take 6 hours of insurance, surety law. A bail enforcement agent has to do 80 hours of training, including tactical, surveillance techniques, constitutional law, due process, field training. There's a lot more that goes into bail enforcement agent knowledge than what a bail agent knows. Also, as far as your question regarding the contract and whether or not the bail enforcement agent would be able to go into the home. So the concern is the bail enforcement agent has to have a reasonable belief that the person they're looking for is in that structure. But we also, our concern is that we've had bail agents and bail enforcement agents and unlicensed people going in, breaking into indemnitors' homes, which may not be part of the contract that they can just go in at any time. They're going into businesses, they're going into workplaces, and what we want to make sure is that they really believe that that person's there and that it doesn't pose a threat to the public by going in there and trying to apprehend that person.
Well, I just want you to know I support your efforts for more transparency and delineation to make sure that we're not storming homes where we're not sure a defendant is, because I've seen some of the morbidity and mortality associated with people that aren't licensed agents going in, and it's like the Wild West. So I want you to know I support what you're trying to do, and I appreciate your answers. Thank you so much.
Thank you very much.
Additional questions? I just have one. The court order, I think Nevada Justice Association brought up how that might infringe upon transparency. So can you explain that again, please?
Sure. Senator Spearman, Alexia Emmerman, for the record, Division of Insurance. So the idea is while we're investigating, we have internal discussions. We talk through what we're seeing, the evidence we have, what the law says, and posing hypotheticals, and it can be for very simple cases, for an individual licensee who failed, was terminated for cause by an insurance company, or it could be something very complex that has to do with solvency or how an insurer responded to a contract, to a claim on a contract. And so we want to be able to have these internal discussions without it affecting the honesty of the conversation. We're not trying to evade the information, if that makes sense. once we figure out what's going on, that's the part that we try to capture in the records. It's the everything else that we're trying to figure out. That's what we want to make sure doesn't go out inadvertently, because sometimes we're wrong. And we don't want that wrong information to go out, because that's not going to help anybody. And the the commissioner can still release the information if the commissioner feels that releasing that information is not going to harm the investigation, and a court can order the release of the information as well.
Thank you. Additional comments?
This is Nick Stosic for the record, and not at this time, but again, we appreciate the opportunity to present this bill today.
Thank you. There were a couple of questions, I think, on the content, and I think you all might be able to work them out. So I've asked Mr. Margarejo to contact everybody, and let's do a huddle and figure out how we get to go. Okay? Thank you. So I'll close the hearing on Senate Bill 57 and open the hearing on Senate Bill 132, sponsored by Senator Pazina. The measure provides provisions relating to insurance coverage for living donors. Welcome to that table, Senator Pazina. You can begin when you're ready.
Good morning, and thank you so much, Chair Spearman, Vice Chairman Lang, and the committee members. My name is Julie Pazina, and I represent Senate District 12 in Clark County. Thank you so much for the opportunity to present Senate Bill 132, which seeks to prohibit discrimination against a living organ donor with regards to any policy or contract of life insurance, life annuity, or health insurance. I'm pleased today to be joined by Elliot Mallon from Alpine Strategies, who is a living organ donor. Organ transplantation is a life-saving procedure that helps patients suffering from various illnesses. However, organ transplantation is only possible if there are organ donors who are willing to donate. According to the Nevada Donor Network, there are 627 Nevadans waiting for a transplant, and more than 104,000 Americans nationwide waiting for a transplant. Regrettably and heartbreakingly, an average of 20 people die each day on the wait list. Living organ donors are those individuals who volunteer to donate an organ, part of an organ, or tissues to a person in need of transplant. Living donation reduces the wait time for a recipient and decreases the chances of a possible recipient from passing away while on the wait list. Living donors are quite simply giving the gift of life.
Thank you, Chair Spearman and members of the committee. For the record, my name is Elliot Mallon. Today, I have the honor and privilege of being here not as a lobbyist on behalf of any client. Rather, I'm here as a Nevadan with the privilege of being here every day working with all of you to make Nevada a better place. I'd like to start by going through an experience that I had that led us to be here today in this hearing on this bill. On February 28th, 2021, which is 2 years, almost 2 years ago in 6 days, I received an email that was sent to my entire family stating that my cousin needed a kidney. Without any hesitation, I filled out the paperwork in the donor application form to hopefully be a donor. On March 25th, 2021, while I was just downstairs in this building, I received a phone call from the hospital in Texas notifying me that I was a potential match. At that moment, we started the process of the preliminary testing. Before I'd come to the legislature, every week I would go to get blood drawn and sent to the medical team in Fort Worth, Texas, to confirm that I was a potential match, which is a very complicated process, actually. By June 12th, 2021, just days after we adjourned sine die, I was in Texas going through extensive testing to see if I was healthy enough and that my kidney would be a final match. On June 25th, 2021, I received a phone call from the hospital informing me that I was a confirmed match and approved to donate my left kidney. And finally, on July 21st, 2021, I gave my cousin my kidney. And since then, I have gone through a lot just to be here. After that surgery, I was given bills to pay for from the anesthesiologist, and the only reason why those bills went away, and living donors are not responsible for the coverage and the expense of donating a kidney. The only reason that those were able to go away is because of what we do in this building and the relationships we have, because we become friends and we start to discuss things. A reporter from Reno wrote a story that went viral. That was one of the top 5 medical stories of last year, and that's what made that go away. And it's those relationships that I'm hoping we can help other donors with another issue. And while today's not about that part, it's a demonstration of what we can do with the relationships we have here. Throughout that entire process, the donor team at Baylor Scott & White in Fort Worth, Texas, would regularly and repeatedly inform me that Nevada has no laws to protect living organ donors, that I would be disqualified from being able to obtain life insurance, and that my rates could potentially increase for my health insurance, reminding me for the last time the morning of the surgery and offering me the opportunity to back out. In fact, 42 other states have enacted some form of protections for living organ donors. Nevada is not one of those 42 states. Nevada, alongside Montana, Wyoming, South Dakota, Michigan, Vermont, New Hampshire, and Tennessee, are the last 8 states that have not enacted this law nor any laws protecting living organ donors. When I brought this up to Senator Pezzina, I was and I remain grateful for her enthusiasm to change this and make Nevada the 43rd state to enact some form of living donor protections. This will help not just me, but plenty of other Nevadans, both donors and recipients, by promising that living donors will be treated as every other normal, healthy individual within the insurance system. The less a donor has to worry about for the remainder of their life, the more likely they will be to make the gift of life to someone in need. Furthermore, there is little to no evidence that being a living organ donor creates a higher mortality rate or the development of end-stage renal failure. Thus, there should be no actuarial risk for a living organ donor within the insurance process. I'd also like to highlight that not all insurance companies even assess a higher premium, but that it is still possible for living organ donors. Today, we move the process forward in fixing this and making Nevada the 43rd state to offer these protections. The language presented to you in SB 132 is taken directly from Virginia, one of the last states to pass the Living Donor Protection Act legislation in 2022, being approved by Governor Youngkin on April 11, 2022. Further, the Virginia law followed Pennsylvania's enactment of the law on June 26, 2021. Alongside state action, federal legislation was introduced in 2021 that would prohibit insurance companies from denying or limiting life, disability, and long-term care insurance to living donors and would prohibit them from charging higher premiums. Our intent is to mirror those laws. Often, it is this lack of insurance protections and potential for higher premiums that create doubt in potential donor matches from following through on the donation. Roughly 1/3 of all donations are through a living organ donor, and this peace of mind can make all the difference in saving another life. SB 132 aims to prevent medical and life insurance companies from denying coverage or causing a living donor to have a higher premium rate for their coverage, mirroring the language from the other states and that federal legislation. I must thank all of the stakeholders that have engaged in discussions about this bill and the impact it will have. I think it is important to note, again, that there are insurance companies here in our state that have been voluntarily participating in this already, and I thank them for doing so. Finally, I want to also thank you for hearing this, as well as Senator Pezzina for carrying this important legislation. I look forward to passing this out of this hardworking committee as we get another step closer to offering protections to Nevadans impacted by organ donation. Because of this bill, we will offer more opportunities for Nevadans to save lives by reducing the stresses associated with living organ donation. And I want to highlight that the important section from this is Section 1, which I will just read so we can get to some questions. With regard to any policy or contract of life insurance, life annuity, or health insurance, no person shall discriminate against a living organ donor by A, refusing to insure the living organ donor, B, refusing to continue and to insure the living organ donor, C, limiting the amount, extent, or kind of coverage available to a living organ donor, or D, charging a living organ donor a different rate, premium, deductible, copay, or coinsurance than that charged to a similarly situated insured who is not a living organ donor for the same coverage, based solely and without any additional actuarial risk upon his or her status as a living organ donor. 2, as used in this section, living organ donor means a living person who donates one or more of his or her organs, including without limitation bone marrow, to be medically transplanted into the body of another person. And this language, again, is taken directly from the Virginia statute, the Pennsylvania statute, as well as the federal bill. With that, thank you so much, and I'm happy to answer any questions.
Thank you, Committee. Senator Daly.
Thank you, Madam Chair, and of course, we want to be better than those other states, so just a couple of questions. I know when the senator was giving her testimony on what organ donors, it says part, a whole, whatever, and she also mentioned, I believe, tissue, and that's where I was going on. Part of my question was, why do we specifically call out bone marrow? And the only thing I could think of was because it's not an organ. But I know there are other things that are not organs which would be covered under the tissue, corneas, various things, and other things I haven't thought of, I'm sure. But I don't know if that definition, even though it may be what the other states have, might need to be clarified a little bit too, so it would cover tissue and other non-organ donations, so we don't intentionally, because if you just list out the one, that's the only one that's covered, and it would be argued that if you only listed out the one, you intended to leave the others out. So I hope maybe we can get a clarification there, or maybe make our law better than the other states.
For the record, Elliot Mallon, Chair, can I go directly to the Senator?
Yeah, and I was just going to ask our legal to comment on the whether tissue is actually an organ or not, so we can get that clarification.
I will let them clarify, then I will answer.
I will need to look up the definitions of tissue and organ, and I'll let the committee know.
Okay, thank you. Senator Daley? Oh, did you have? Okay.
Chair,
I'm
can
sorry.
I just respond really fast, please?
Yeah.
Elliot Mallon for the record. Or living organ donation typically applies to kidney, I believe pancreas, liver. Tissue is usually of a deceased donor, from my understanding.
Sorry, but would it create this prohibition or insurance question that we're trying to avoid is the only thing. Like I said, I think it's just the technical question. Wouldn't want to leave anybody out or leave doubt as to a person wanting to be a living donor for those other reasons, and then have an insurance question later. And then we have to come back and fix it again.
Thank you so much, Julie Pizzina, for the record. Thank you so much for the question. We'll wait to hear back from legal and then get back with you. Thank you.
Okay, thank you. Additional questions? Or remember, committee members, let's do one bite of the apple and then we'll come back. I see Senator Stone and then Senator Scheibel.
Yeah, thank you, Madam Chair. I do have a limited medical background, so we have defined organs in the body. The organs can be composed of tissues, so tissues are all over the body. So, and also another very important organ that's transplanted is lungs, pulmonary, right? So we want to make sure we include that. So, if to complement my colleague over here, to make this even better than the other states, maybe we should have language that says that any organ or tissues that can be transplanted without causing the loss of life of the donor shall be considered as a part of this legislation. Just offer that up. Thank you.
Julie Pizzina for the record. Thank you so much, Senator, and we will wait to hear from legal regarding tissue, and we'll look at that. Thank you both so much.
Thank you so much for bringing this bill. I think this is a fantastic idea, and I'm really happy to see that we're moving forward with it. I want to make sure that I'm understanding something correctly. It looks like this would cover the situation I'm thinking about, and I want to make sure. So if I'm a living organ donor and there are some complications with that procedure, I get an infection or I don't know, there's some kind of complication, I need further medical treatment as a result of having had what I think would be considered an elective procedure to donate an organ. This Section C is saying that the insurance company can't limit my my coverage. They can't say, we're not going to cover your antibiotics because the surgery was elective. It would be just like if I had to have my kidney removed, they would have to cover the antibiotics for an infection that I got afterwards.
Thank you for the question, Elliot Mallon, for the record. So in that scenario, the recipient's insurance would actually cover that because it would be as a result of the direct surgery. So for example, when I donated my kidney, I had a issue here where my incision reopened and I couldn't actually go anywhere here to take care of it. That wouldn't cost an arm and a leg because I'd have to go to the ER. The recipient's insurance covered me to go back to Texas and have it reclosed.
That's very interesting. Thank you.
Very kind of them.
Think our legal department has answer for us.
Yes, thank you. Well, in addition to the definitions of organ and tissue medically, in the NRS, when organs are described, there is in the NRS, organs and tissue are described as separate things. So in NRS sections where both of those are intended to be captured, the terms do include organ and tissue. So I think in this case, the definition of organ would not include tissue.
So that would need to be clarified in the legislation?
If the desire of the committee was to have this provision apply to tissue donation, then there would need to be the addition of the word tissue to the definition.
Thank you. Additional questions? Well, I'm just going to make a statement. When I heard about this, it brought back memories. I have a sister who's on dialysis, and that's one of the reasons why she can't get one, because she's here in Nevada. So, thank you. You have anybody else going to present? Okay. So we'll go now to support. Anyone wishing to testify in support, please come forward. Don't see one in Las Vegas, but as one leaves, another come, and we'll move through this. Thank you. Begin.
Good morning, Chair Spear. Dan Musgrove today on behalf of Nevada Donor Network. Nevada Donor Network is one of 57 organ procurement organizations licensed here in the United States. We are the only Nevada-based organ procurement organization. We are absolutely in support of this bill. I think you heard an incredible story and a very magnanimous gift that Mr. Malin was willing to give, and we certainly don't want to have someone who is willing to do that somehow be dissuaded from giving because of an insurance issue. Again, you heard the stats, 600 Nevada folks are waiting right now. It's so important that we remove those barriers to the life-saving gift of organ donation. And for that, we stand absolutely in support. I did ask the question by text whether a living person can give tissue. If I get that, I'll let you all know that.
Thank you, Madam Chair and members of the committee. For the record, my name is Paige Barnes. On behalf of Fresenius Medical Care, I am here to express support and gratitude for SB 132, which requires health and life insurance policies to provide insurance coverage for living donors and generally prohibits denial or conditioning of coverage based on the status of being a living donor. Fresenius Medical Care provides care for thousands of Nevadans who rely on life-saving dialysis treatment at one of our outpatient dialysis clinics in the state. For patients with end-stage renal disease whose kidneys have failed, they either need regular dialysis treatment or a kidney transplant to survive. While dialysis is a life-saving treatment that continues to improve and advance, kidney transplant is the treatment of choice for patients with end-stage renal disease. Unfortunately, access to transplants is limited for patients for a variety of reasons. Nearly 90,000 people in the U.S. are waiting for kidney transplants, and about 17,000 people per year actually receive one. Fresenius Medical Care supports the efforts to encourage and increase the number of kidney transplants and the number of organ donations. SB 132 will help reduce barriers for living organ donation, and we ask for your support of this legislation. Thank you.
Can you spell your name, please?
Of course, Paigebarnes.
Thank you.
Good morning, Chair Spearman and committee members. My name is Nick Shepak, Nickshepak. I am here today as a citizen of Nevada, as a friend of a living organ donor, and as someone who has lost family members to organ failure. I want to first thank the committee, especially Senators Daley and Stone, for making sure that we're taking a good bill and pushing it as far as we can. It's one of my favorite things to see in this building. But I just for a moment want to mention, we talk a lot about bravery, and we talk a lot about heroism, and we often speak about it as decisions made in a moment or in a split second. But being a living organ donor is something, as we heard, that takes a very long time. You have to think about what is going to happen to you. You have to jump through hoops. And right before you go under the knife, you are told you might not be able to get life insurance, and you may not have affordable health insurance. To go through all of that and still save a life, that is true heroism. That is true bravery. And whatever this state can do to support that, I think is something that we can collectively get behind. And I thank you very much for taking up this bill, and we urge your support. Thank you.
Good morning, Madam Chair. Again, Michael Hillerby for the record on behalf of the American Council of Life Insurers. Very pleased to be here today in support of the bill. We want to thank the sponsors and the proponents for using the language that we've worked on over the years with the National Kidney Foundation. We've worked on that across the states and in Congress to provide, again, some consistency and some language that works and reflects the realities of the industry. So we're very thrilled to be here today to support this bill. Thank you.
Thank you, Madam Chair, members of the committee. For the record, Jessica Ferrato here today in my personal capacity. I want to thank Senator Pezzina for bringing this bill forward. This bill provides support for those who make the incredible choice to give the gift of life. To make a very long story short, I am a living kidney donor and a living kidney recipient. My sister is the recipient of 2 living kidney donations. My dad is a living kidney donor, and my stepmom is a living kidney donor. Just a few statistics about kidneys. Every 14 minutes, someone is added to the kidney transplant wait list. 13 people die every single day waiting for a kidney transplant. We don't want to create barriers for those willing to donate with the high needs of patients awaiting a transplant. I want to thank the committee for your time and urge your support on the bill. Thank you.
Morning, Madam Chair, members of the committee and staff. My name is Rick McCann. I represent the Nevada Association of Public Safety Officers and the Nevada Law Enforcement Coalition. I want to thank Senator Pezzina and the co-sponsors for this bill. Living organ donors save lives. We know that. Discriminating against those people for any pecuniary gain, frankly, is deplorable. One personal note. I have a chance to work with law enforcement each and every day. They are my heroes. Today, I can add some additional people to my list of heroes. Elliot, the lady who just testified a moment ago before me, people who have done this. They are heroes. And we need to make sure that people do not go out of their way to hurt our heroes. For that reason, we support SB 132, and we encourage this committee to do the same. Thank you.
Good morning, Chair, committee members. Nick Vanderpool here as myself, as a bone marrow donor and the grandson of the 8th transplant, heart transplant at Stanford and the 87th transplant in the world. This issue is very important to our family. We appreciate Senator Pezzina for bringing this legislation forward, and we urge your support. Thank you.
Anyone else in Carson City? Support? I don't see anyone in Las Vegas. BPS, we have anyone on the phone?
If you would like to testify in support of SB 132, please press star 9 now on your phone to take the place in the queue.
I wasn't paying attention. No one's on the phone.
Yes, ma'am, we have a caller.
Okay.
Caller with the last 3 digits of
Good
490.
morning.
Please continue.
Good morning. CYRUS Cyrus Hojati. I support this bill. A lot of good ideas. And by the way, it's very windy out here. I can't drive on these freeways. Thank you.
If you recently just joined us, we are currently in support of SB 132. If you would like to testify in support, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 235, please continue.
Good morning. This is Dr. Barry Cole from Reno, Nevada. I have no relevant affiliation, but I would support anything that increases the pool of living donors. We have a constant shortage of organ donations, not just in Nevada, but in the United States. Anything that gives equity to our donors is critical. So really, I want to just say ditto. Thank you.
Can you spell your name, sir?
I'm sorry, Chair, he is no longer on the line.
I think we got it.
You
Anyone?
have no more callers wishing to support at this time.
Okay, thank you. We'll move now to hear testimony in opposition of Senate Bill 132. We'll start here in Carson City. Any opposition in Las Vegas? VPS, is there any opposition on the phone?
Testify in opposition of SB 132. Please press star 9 now to take your place in the queue. Chair, you have no callers in opposition at this time.
Is there anyone here willing to testify or wants to testify in neutral on this bill?
Good morning, Madam Chair and committee members. My name is Maya Holmes. I am the Health Policy Director for the Culinary Health Fund, and we wanted to testify in neutral today. The Culinary Health Fund is a nonprofit labor management trust that provides health benefits for the members of the Culinary Workers Union and their dependents, about 130,000 lives. We also are members of the Health Services Coalition. We're neutral today. We understand this is a very important issue. We just wanted to hear the testimony, understand the intent, and we're working through understanding how it impacts our plans and other members of the Health Services Coalition, which represents 25 employer and labor groups. We do not believe that any of our plans, charge higher premiums or copays and co-insurance, but we're checking that. It's an issue because some of the plans are smaller plans, they're nonprofits, they're self-funded, and they're also on, many are subject to collective bargaining agreements where the rates are set for 5 years. So if there's major adjustments in a plan, it can be difficult to absorb that. So we're just weighing that, and we just wanted to put a tack in that for right now, and we'll get back to the sponsors as soon as possible on that. Thank you.
Thank you. Anyone else testifying neutral? Senator Pezzina, closing comments? Is anyone testifying neutral on the phone?
If you would like to testify neutral on SB 132, please press star 9 now to take your place in the queue. Chair, you have no callers wishing to testify neutral at this time.
Okay, thank you. I believe we have a question from Senator Buck.
Thank you, Chair Spearman, and thank you so much for carrying this bill. I just was wondering, I was hearing from, Stanford and Texas, and so I'm wondering, are there other organs aside from kidney, or do Nevadans have to go outside of Nevada to get transplants?
Thank you, Madam Chair. Dan Musgrove on behalf of Nevada Donor Network. Currently in Nevada, the only program for transplant is at UMC, which is kidney. So any other organ, you have to go out of state, but very candidly, Nevada Donor Network is working on a transplant institute. We received some dollars from IFC last session to work on creating more transplant opportunities here in the state of Nevada. We're working with hospitals. We're not going to build a building, but we're going to work with existing hospitals we want to expand UMCs, kidney program. We want to go to liver next, and then we have to work on the other organs. But unfortunately, yes, most Nevadans have to go out of state to receive their life-saving operations, and it's very, very hard on families.
Additional questions, committee members? Thank you again. And as I said, it's a personal thing, because if we could do it, then my sister wouldn't have been on dialysis 5 years. So, any closing remarks?
Thank you so much, Chair, Vice Chair, Committee, and thank you so much to all of the co-sponsors on this bill as well. I also wanted to clarify from the Nevada Donor Network, some questions about tissue were asked rightfully, and thank you for those questions. A living donor cannot donate tissue, but they can donate reproductive tissue, which would be sperm, egg, or placenta or cord. So just to clarify that. As my closing remarks, we can't thank you enough for hearing SB 132. Living organ donation is a selfless act that saves lives. And when you think of those lives, think of the 627 Nevadans who are waiting for a transplant right now. It's important to recognize the insurance issues and concerns that living organ donors face. Insurance companies and policymakers must work together to ensure that living organ donors have access to affordable health insurance coverage and life insurance. Only then can we truly support and recognize the valuable life-saving contribution of our living organ donors. Thank you so much, and I'll pass it to Elliot Mallon.
Thank you, Chair. Elliot Mallon for the record. I want to thank everybody for hearing this and the very thoughtful questions. I don't consider myself to be a hero. I love my cousin. We grew up together. We're very close. It was not there was no moment that I ever thought about not donating my kidney to him. I often say that it was the second easiest decision I've ever made, the first being marrying my wife, and I have to say that one, otherwise I'd be in trouble. It was an interesting experience, I will put it that way, but it was a good experience. It's not something I have ever regretted. I will never regret doing that, and it's helped my cousin live a better life. I don't know how many of you know this, but when you receive an organ for transplant, you go on immunosuppressants for the rest of your life. The timeline I gave you was during the height of COVID, which made that pressure even more stressful on him. If we can do whatever we can to help others live a better life and not be on dialysis, dialysis is hard. It's hard on families, it's hard on the body. We can make a real difference, and we can really help a lot of Nevadans, myself included. And I'm a little bit ashamed, to be honest with you, that I didn't even know this was a problem until it affected me. And so today I'm hoping we can help many Nevadans live a fulfilling life and hopefully move more people into being a living donor. So thank you again.
Thank you. Additional questions, committee members? Okay. I'm going to do something that I usually don't do, but I want to vote this out of committee today. It seems that it's pretty important, and I am in consideration of the testimony about the ERISA plans, but I think they may be exempt. And if I am wrong about that, then let's talk, and we can add an amendment. Okay? So I'll accept a motion.
Second.
Have a first by Vice Chair Lang, second was by Senator Stone. Additional questions? All those in favor, aye. Aye. Any opposed? And the ayes have it. Let the record show that this bill was voted yes unanimously. Thank you. Thank you, Senator Pezzina. Close the hearing now on Senate Bill 132, and we'll open the hearing on Senate Bill 147, sponsored by Senator Lang. The measure makes changes relating to employment.
Good morning, Chair Spearman, Committee members, I'm Roberta Lang, representing Senate District 7 in Las Vegas. Thank you for the opportunity to present Senate Bill 147, a bill requiring payment of certain wages and compensation to an employee when employees are laid off. We passed this bill last session, and the Labor Commissioner wanted us to strengthen it so he had more, so that they had more teeth in enforcing it. And so that's what we're here today, is to build upon the legislation that you all passed last session. According to a survey of Mental Health America, 58% of those surveyed worry about the ability to pay for day-to-day living expenses, while 20% responded that they were very concerned. Additionally, 25% of those with anxiety and depression said that financial problems were the main contributing factor to the mental health problems. Unfortunately, many employees live in a financial insecurity and live paycheck to paycheck to cover their expenses, pay bills, and support their families. When an employee is terminated or laid off, it can be difficult and a stressful time. Not receiving their final paycheck on time can exacerbate an already stressful situation, leaving the employee struggling to make ends meet. This is especially true for employees that may have been counting on that final paycheck to help them transition into a new job or to cover their expenses until they find a new source of income. For these reasons and more, under current Nevada law, employers are required to pay their employees their final wages in full immediately following the termination of employment. If the employer fails to pay the wages or compensation within 3 days after the wages become due, the wages of the employee continue at the same rate for each day they go until their final paycheck is paid in full for up to 30 days, whichever is less. Senate Bill 147 builds upon this work to provide that when an employer lays off an employee, the wages and compensation earned and unpaid at the time of such layoff also become due and payable immediately. In addition, if the employer fails to pay the wages or compensation of a laid-off employee within 3 days, the wages of the employee also continue at the same rate for each day until the laid-off employee goes without their final paycheck until paid in full, or up to 30 days, whichever is less. Finally, the bill provides that the term wages includes the amounts owed to the laid-off employee. With that, I will pass it to, are you going to talk next? Randy Saltero.
Good morning, Chair, members of the committee. For the record, Randy Saltero, representing IATSE, International Alliance of Theatrical Stage Employees, but also the citizens of the state of Nevada. Here we go again. We did this bill last session to help workers to get their pay when they leave employment. With me here today is Phil Janes, president of the International Alliance of Theatrical Stage Employees, who's going to talk about a situation that's happened with their organization in folks that have found a way to circumvent the law and move around it. And so, and for that reason, we had to come back here and make an amendment to this bill that was passed last time. In the bill, Section 1, subsection 3, adds the words "or laid off." Pretty simple word. In Section 2, twice, it says whenever an employer discharges or lays off an employee. Further down, such discharge or layoff shall become due and payable immediately. Section 3, within 3 days after the wages or compensation of a discharged or laid off employee becomes due. And further down in Section 3, B, the wages or compensation going on quit or discharge or laid off until paid for 30 days. This bill adds one word in several different places, 2 words in several different places. That's because there was an opportunity that employers have found where if you don't have the word laid off, and they could say, well, I didn't discharge these people, so they're still employees. I don't have to pay them. as Senator Lang talked about, people need their checks. People need to pay their rent. People need to feed their families. People need to pay their bills, put gasoline in their cars. People need to go to work. They need to get paid for when they do go to work. With that, I thank you for your time, Chair, members of the committee. I want to turn this over to Phil Janes to talk a little bit about a real-world situation that would be impacted by this bill. Thank you so much.
Good morning, Madam Chair, senators on the committee. My name is Phil Janes. I'm the president of International Alliance of Theatrical Stage Employees, Local 720 in Las Vegas. For the record, PHILJAYNES. In 2019, one of our large strip employers had a problem with onboarding new employees. The outcome of this problem was that over 200 stagehands were not paid for almost a year for work that they had performed. Because of this, we wrote SB 245, which creates a mechanism by which if somebody is not paid for work they performed, they can go to the Labor Commission, and the Labor Commissioner will open an investigation to get them paid. I'm happy to say that SB 245 was signed into law in the end of 2021 session. A couple months later, in the fall of 2021, work was picking back up at a rapid pace, but we started hearing complaints from about our largest employer. People weren't getting paid correctly or at all. We reached out to the employer and were told that the reasons for the pay issues are that they are in the middle of a merger and that they are short-staffed. Since the fall of 2021 to the beginning of this month, there have been 465 pay issues with this employer. That number includes missing hours, wrong rates of pay, and 117 workers that didn't even receive a check. Local 720 has written almost 200 grievances and had to hire 2 payroll specialists to do the work that the employer can't seem to figure out. During the grievance process, the employer was made aware of SB 245. After the employer met with their attorneys, they informed us that law only applied to terminated employees. They took the argument to the Labor Commission, and the Labor Commissioner ultimately sided with the employer. Currently, there are 121 open payroll issues equating to over $50,000 of unpaid wages. That's of last week. Which brings us to today. The vast majority of stagehands are not employees in the sense that they have a guaranteed work week or progressive discipline. They are only guaranteed to have a 4-hour minimum for the work that they're dispatched to do. Essentially, they are terminated at the end of every job. SB 147 would close this loophole, and that is why Local 720 is supporting this bill. Thank you.
Thank you, Madam Chair, and we stand ready to answer any questions.
Thank you. Committee members, any questions? I just have one before we get, how much and how long have they been waiting?
It depends. Phil Janes for the record. It depends. There was 465 originally. Some of them would get paid in about a month. Some of them, there's some that are still going on since the fall of 2021.
Committee members. Senator Daly.
Thank you, Madam Chair. And just a couple of comments. Fully support the bill. I hope it solves the problem. Unfortunately, we'll probably see ourselves back here in the future sometime, because I know in the construction industry we'd have employers that say they're not discharged and they're not laid off either. We just don't have work today, and they'll do that for a week until it's normal payday and then pay them. It's an issue that we've had. But I think a question, if you will, where it says the person will be paid at their regular rate for the first 30 days. How has that been interpreted? Is it for the regular shift, 8 hours, or portion thereof for a day, or is it continuous for a 24-hour period for up to 30 days? Has there been any determination, or how has it been enforced, or what have people looked at as far as the penalty for the 30 days?
Madam Chair, through you to Senator Daly.
Yeah, just go direct.
Thank you, Senator. For the record, Randy Saltero. The legislative intent was to pay that person, if there was a penalty phase, would be to pay that person at the normal schedule that they would have kept if they were continuing to work. If that was an 8-hour day, in the case of what Mr. James is talking about, normally they're on a 4-hour guaranteed dispatch, so it would continue as that 4-hour day. That was the legislative intent that we had last session when we originally did SB 245.
And thank you, if I can follow up. And I understand, and there's a few things, and I wanted to clarify that because it could be a deal. And I don't know that we need any changes. Like I said, hopefully we're not back in the future and this fixes this. But I do know in most collective bargaining agreements, at least in the construction industry, there is no 3-day waiting period. It starts the next day. We say that most of the agreements say that the person gets paid for 8 hours at time and a half until he gets paid. And there is no limit out 30 days. So just some of the things that, we may have to stiffen it up if it continues as a problem. But most collective bargaining agreements already have a better standard, and maybe we should look at that in the future. Thank you.
If I may, Senator. For the record, Randy Saltero, Senator Daley, that's true. In a lot of collective bargaining agreements, there are provisions that would provide for that. This bill is for the people of the state of Nevada and to cover anybody who works, not just if you're under a collective bargaining agreement or anywhere else. And I think we believe that that's what's important, and that was the intent of SB 245 and 21. And that's what the intent is, to hopefully close those loopholes for all employees with SB 147.
And I understand I wasn't suggesting that it would be only to people with collective bargaining agreements, but I'm just saying that maybe we should make the standard for all people similar to what they are already existent in many industries in the state. So,
thank you so much. Thank you, Chair.
Senator Stone.
Thank you, Madam Chair, and I also support the spirit of the bill. Just want to clarify some things. So an employer can basically take somebody that has historically worked 30 or 40 hours a week and just say, we're going to pay you for 4 hours, and that way we're not terminating you, we're not firing you, and the employee's going to figure out, well, how the heck do I pay my bills? So how do we get around that fact that they're still on for 4 hours? So are we basically allowing the employee to demand that they're in laid off status and therefore they're entitled to all these wages for the future I'm talking about? And then also, I see that this bill becomes effective into law if it's signed July 1st, 2023. Is there any retroactivity to help the 121 that have over $50,000 in wages that are due to them and haven't been paid?
Phil James for the record. It would be great if there was retroactivity. We did not address that in the bill, though. In our world, the stagehand world, you can make a living, a very good living, on the bounce. But ultimately, it all comes down to your relationships with the employer. And the guy that's always been bringing you onto his calls, if he retires, moves on, and they hire somebody else, then there's a good chance that you're going to take a hit in your income because on the bounce, you are literally guaranteed, and by contract for most of the contracts, 4 hours. The problem with this, the thing that we're trying to address here is not those guys. We're trying to address the guys that aren't being paid correctly and stopping an employer from coming in and going, well, you weren't terminated. We didn't terminate you. So therefore, we file a grievance and we'll do the slow roll. Hopefully this will fix that problem and speed the process up. But the guys on the bounce, we all understand, most of us have done it as stagehands, that it's feast or famine. You just got to plan your life out accordingly. But it all goes with the assumption that has been around since civilization. If I do work for you, I get paid by you. Mm-hmm. It's a very simple, basic human process that's been around for eons.
Thank you.
You're welcome.
Committee members, additional questions? Okay. I just have another one. How much in terms of wages? Just please let me be clear.
Phil Janes for the record.
Okay, and just before you, because here's what stands out in my mind, because we're talking about people trying to come back from COVID.
Right.
And families experiencing catastrophic financial distress. So how much and for how long?
For the 121 that are out there now, and all of those, they can be the wrong rate. So somebody goes out there and they're supposed to be paid $40 an hour and they paid them $30 an hour. It can be missing hours. Say they worked for 8 hours and they only paid them for 6. Or people that have not even received a paycheck for the work that they went. Out of those 121 that are still active grievances in our system, it's over $50,000. It's $458 averaged per person. There is one person on that list that is owed $3,600 for work that he completed. Now, the original list of 465 that started growing, all of the other ones past that 121 have been fixed. It was just an incredibly slow process to get them fixed, and like I said before, which included us hiring 2 full-time employees to fix the problem of the employer, to make sure those guys got paid. And gals.
Okay, one last question from me. I think, Senator Buck, did you have a question? Okay, so would this apply? I know there were some employers who eliminated positions. So would this apply to those people for whom positions were eliminated?
No. When those positions get eliminated, we would just expect those people to get paid.
And if they don't?
Then it would apply.
So do we need to put that in the bill, that language in the bill? No?
Would think so.
Legal?
No. I think under current law, the current law requires the payment of unpaid wages on discharge. So when there's a separation from service, a downsizing or elimination of a position, that would be a discharge under current law. And so we wouldn't need to amend the bill to capture that situation.
And I ask a question because I would think that in the spirit of SB 245, we wouldn't have to have 147. So when we come down to semantics, I just want to make sure that people whose position is eliminated, they would still be working there, that they are captured, and that there's no legal room to say, well, no, your position was eliminated, you weren't discharged, we just eliminated your position. Does that make sense to you? Okay. Senator Buck.
Thank you, Chair Spearman. I was just wondering, as you're out there talking to employers, I just wondered the why, because you usually work and you get paid. So what is the reasoning that many are giving?
Phil Janes for the record. This situation is all one employer. They were going through a merger. They were coming, they laid off a lot of people during the pandemic for their management, office staff, payroll staff, people like that. They were integrating a new payroll system, which we understand all that, but there's got to be a time limit. This stuff was stretching on for a very long time, but that was the why. It was, they wanted, we would talk to the people, the CEOs and the head of HRs and those people, the head of payroll. They want to pay, but they just couldn't get their systems operating. They couldn't catch up. And I think that holding back, bringing people back on their side, exacerbated the issue. It was kind of a perfect storm, but the storm's not over. Like I said, there's still 121 people out there now that are waiting for either a check or monies that they're owed because they were shorted.
If I may, so this is an isolated incident, or you see it in many employers? And then what happens if there's a bankruptcy? Are they just out then?
For the record, Randy Saltero. Senator Buck, I believe that you'll hear from some folks here testifying in support of this bill from other industries that might have similar situations that have happened. If those persons aren't here today, are part of our going around to talk to you folks after this in lobbying you is for your support will be to bring up those things, and we'll address those. Thank you.
Any questions? Okay, I still have one question. How many and how long? But we'll move on. You have anybody else that's going to present? Senator Lang? No? Okay, we'll start now with testimony and support. And they're going through a merger, and they can't anyway. Begin when you're ready.
Thank you, Chairwoman, and the rest of the members of the committee. My name is Vince Saavedra, for the record. Vince, V-I-N-C-E, Saavedra, S-A-A-V-E-D-R-A. I am the Executive Secretary Treasurer to the Southern Nevada Building Trades Unions. We're in support of this bill for many reasons. In the construction industry, we pride ourselves in working ourselves out of a job. The faster we get it done, the faster we get laid off, that means we did a great job. Unfortunately, sometimes the employer, when the job is finished, they don't want to lay off the employee because they're great employees, they just don't have the work, so they don't want to lay them off. That's unfair to the worker. So they string them along saying, call in next week, call in next week. When the job's not ready due to inclement weather or just whatever the situation is, they're not getting their layoff check. Being a union member, we pride ourselves in building, buying, being American. The American way has always been an honest day's work for an honest day's pay. And we believe in that layoff is payoff, and every Nevadan deserves to get paid. Thank you.
Greg Esposito, representing the Nevada State Pipe Trades, Chairwoman and Senators. We are fully in support of this bill, but I'd like to answer Senator Buck's question as far as the why. In a short phrase, the complete disregard for wage earners. I know we're talking about, the testimony was about IATSE workers, but let me please tell you a personal story. A friend of mine who's on the spectrum was working for a fast food establishment, and they knew, and they know that when you're earning pretty much the lowest wages possible, they can take advantage of you because most people who are low wage earners don't know the law and don't know the rules that govern how they get paid and why. Fortunately, she knew me and she came to me with the problem. And that fast food restaurant owed her hundreds of dollars in back wages where they had falsified her hour records and not paid her for overtime that she had worked. And we had to go to the Labor Commissioner. And they fought us over, I think it was like $500 was the final amount that they owed. But they knew if they kept fighting, they could just get away with not paying their workers. But they didn't know that I knew the law and that the Labor Commissioner was going to find things. And through this law, she finally got paid. And she finally got the penalty that she was owed. And that made a huge difference in her life. Now imagine that story across the state. As my colleague, Mr. Soltero, said, this isn't just for any one group of people, it's for the entire state. Because people are getting cheated every day out of wages that they're owed, and it's going to cause bigger problems down the road as people decide they're not going to take it anymore. So I'm in support of this bill. My organization is in support of this bill. Thank you very much for your time.
Good morning, Chair Spearman and members of the committee. For the record, my name is Susie Martinez, and I am the Executive Secretary Treasurer for the Nevada State AFL-CIO. And on behalf of over 150,000 members and 120 unions, we are in full support of this bill, for Senate Bill 147. Thank you very much.
Good morning, Chair, Committee. My name is Fran Alvarez, and I represent the Teamsters in Nevada. Teamsters work the convention industry. When a convention comes in, there are many small companies who bring their booths, which the Teamsters work. Many of these people leave town and do not pay their workers. And again, we have to go to the labor board and track these people down wherever they live. And some of them, they come from out of the country. And it's very difficult to get these people paid. Workers, they need to be paid, and they need to be paid on time. And we are hoping that these two words that are fixing this bill, laid off, will make these employers understand you must pay these workers. Thank you very much, and I ask for your support of SB 147.
Good morning, Madam Chairman, Committee. My name is Edward Goodrich. I'm the Political Director of the International Alliance of Theatrical Stage Employees, Local 363 in Reno. We too have this problem. We've had employers miss hours. We look in our office at times and we simply say, why can't they add 1 + 1? Why don't they understand what, wage times hours equals? It's really frustrating. And I've just got to echo President James' frustration with the whole process. And this would help solve it. And I would also like to say if the committee would like to amend the penalty to be time and a half or double time or something like that, that might encourage these employers to at least learn a little math. Thank you for your time.
Good morning, Madam Chair, members of the committee and staff. My name is Rick McCann, Nevada Association of Public Safety Officers, and a member of the Nevada Law Enforcement Coalition. I want to thank Senator Lang and her co-sponsors for this bill. Why am I here? I represent cops. We don't have these problems, but cops are part of the community. I don't have problems like this because we have collective bargaining agreements and our departments typically take care of these things. Doesn't mean it's right when it happens to other people. Protecting discharged employees and to guarantee their wages is important. Protecting laid off employees by protecting their wages is equally important. I won't belabor it other than to say for the reasons that have been stated here today, we support SB 147 and we encourage this committee to do the same. Thank you.
Do we have anyone in support in Las Vegas? Seeing none. BPS, anyone on the phone?
If you would like to testify in support of SB 147, please press *9 now on your phone to take your place in the queue. Again, if you would like to testify in support of SB 147, please press *9 now. Chair, you have no one in support at this time.
Thank you. Next, we'll hear testimony in opposition to Senate Bill 147. We'll come here to Carson City, and then we'll go to Las Vegas.
Good morning, Chair Spearman and committee members. For the record, Misty Grimmer with the Ferraro Group representing the Nevada Resort Association. Thank you for allowing me to speak regarding SB 147. We appreciate the intentions of the sponsor to get at bad actors who would use the term layoff as a way to avoid paying employees what they are owed. Our concern with the bill comes from the possible unintended consequences that could result for some of our employees. In the gaming industry, the need for employees may ebb and flow quite a bit depending on the season and the demand and show schedules. So temporary layoffs are not uncommon, but employees usually understand that they will be of short duration and that most likely they will be coming back. To a great extent, there are rules in our contracts tied to the seniority of the employee that govern how we manage these layoffs. We have no issues with the portion of the bill that requires the payment of wages. Our concern with the bill is focused on the other compensation that may be due to the person at the time of being laid off. As drafted, we are worried that a person could lose benefits they have accrued, such as PTO or vacation time and have to start from scratch again when they return. We appreciate the opportunity to work with the bill sponsor on a possible distinction between short-term and long-term layoffs, at least with respect to the benefits portion of the bill. Thank you so much for your time.
Thank you. And I would encourage you to talk to the sponsor with those concerns. Anyone else here in opposition to Senate Bill 147? Las Vegas? Seeing none, BPS, anyone on the phone?
If you would like to testify in opposition of SB 147, please press star 9 now to take your place in the queue. Chair, you have no callers in opposition at this time.
Thank you. Is there anyone wishing to testify neutral, either here in Carson City? I don't see anyone in Las Vegas. BPS, anyone on the phone?
If you would like to testify neutral on SB 147, please press star 9 now to take your place in the queue. Chair, you have no one wishing to testify neutral at this time.
Thank you. Senator Lang, you want to come back and...
Thank you, Chair Spearman, and thank you for your questions for the committee. Look, in this time of insecurities with people and their paychecks, it is so important that people get paid in a timely manner and that we go after the bad actors. And if they aren't paying on time, we make penalties for them to pay on time. People live from paycheck to paycheck, unfortunately. It's a reality, and I think we need to pass Senate Bill 147 so that we can make those enforcements happen and get people, like Mr. Janes talked about, the pay that's owed to them. Thank you so much.
So, Senator Lang, will you get with representatives from NRA?
Yes, we talked this morning, and we're going to have further conversation.
Okay, because I would think that if that is the only obstruction, that there could be language in there that could delineate
Yes,
between the two. But
we'd be happy to.
okay, thank you. Okay, with that, I'll close the hearing on Senate Bill 147, and we'll open it up now for public comment, either here in Carson City or in Las Vegas. And public comment means that you're not coming to the table to testify on anything we've heard today. It means that you're coming here to say a public comment. Otherwise, you should have testified when we were hearing the bills. Just saying. Don't see anybody in Las Vegas. BPS, anyone on the phone?
If you would like to speak in public comment, please press star 9 now to take your place in the queue. Caller, you are unmuted. Please continue.
Hello. My name is John Carlo, the young gentleman from Las Vegas. I want to be your friend. And I will go on record to say that we need to raise the pay for the legislators in Carson City. But I also want to be a friend to the unborn. Proverbs 31 verse 8 says, "Open thy mouth for the dumb in the case of such as are appointed to destruction." I like to remind the legislator that our country was built on Judeo-Christian values. There was the story of Moses when the local government, Pharaoh, feared that the slaves would outnumber the Egyptians. So he wanted to exterminate the Hebrew race. But as I've heard other legislators on this board talk about the butterfly effect and the multiplying effect, I like for you to think about when one child is murdered, an unborn child is murdered in his mother's womb, think about the butterfly effect and how many more children are being exterminated. Also, the Roman Emperor, King Nero, wanted to kill the Davidic bloodline. So he ordered that the children of Bethlehem to be murdered. Now, in the year of 2023, the local government, in like manner, entices the spilling of
Caller, you have less than a
blood.
minute. You have
And the
less than a
Bible
minute.
says-
Caller, you have less than a minute. Please wrap up.
God says, these 6 things that the Lord hates, 7 are an abomination unto him: a proud look, a lying tongue, and hands that shed innocent blood. I would like to warn you guys, because I've heard about family tragedies. God can bring anything. I prayed for an earthquake last April, and God sent an earthquake to northwest Las Vegas. Now, I don't want the wrath of God to be upon Nevada, but we need to walk in the fear of God. And as we need to obey the Lord, we need to protect human life, SB 131. And,
Sir, we're not
know
taking
that
testimony
we will
on
stand
Senate Bill
before God.
131. We are not taking testimony on Senate Bill 131. If you have anything to say about something other than what we've already discussed either Monday or today, you can continue. If not, we thank you for your comments. Thank you. So, members, are there
Chair,
any
you have
comments
no
from
more
the
callers at
members?
this time.
No more callers? You said no more callers?
Chair, you have no more callers. this
Thank
time.
you.
No more callers.
Members, any comments before we adjourn? Okie dokie. So this concludes our meeting for today, and our next meeting will be Monday, February 27th at 8 a.m. Thank you. We are adjourned.